The crime at Tempi and the corrupt Contract 717 revealed, in the most painful way, an institutional abnormality that has persisted for decades. But let us start with the basics. In the European Union, a fundamental principle applies: the principle of the supremacy of union law. This means that no national law can conflict with the directly applicable law of the European Union, which prevails. And in this specific case, no provision of any EU member state may obstruct the investigation and punishment of those who misuse European funds. In Greece, however, we have Article 86 of the Constitution, a provision that turns ministers into a special caste of citizens who are not accountable to their natural judge, but to their colleagues in Parliament. This protective wall, which shields precisely those who first decide how EU funds will be allocated, that is, politicians, stands in direct conflict with European legality. And yet, instead of Europe tearing it down, it stumbles upon it. In the case of Tempi, it not only stumbled, it did not even investigate the criminal liability of politicians and sent the matter directly to the Greek parliament, under the false justification of a short statute of limitations. However, this limitation period was abolished in 2019. So how did the European Public Prosecutor's Office rely on it in 2023? And all this while even the Greek government, through official statements of the Prime Minister and its representatives, publicly declared that the 2019 constitutional revision abolished the short limitation period. The problem arising from this stance of the EPPO is enormous, and as a result, it did not exercise any of its duties regarding the political responsibilities in the Tempi case. But even in principle, as long as the privileged procedure of Article 86 remains in force, that is, as long as parliamentary approval is required for criminal investigation and prosecution of politicians, the protection of politicians remains unlawfully absolute. The scandal in the Tempi crime is not only that the abolition of the statute of limitations in 2019 was ignored. It is that the political system itself, in 2025, maintains a feudal privilege allowing the parliamentary majority of the day to exempt politicians from criminal liability for crimes. Article 86 does not simply need improvement. It is a foreign body within the rule of law and must be abolished formally as well. Within this framework, the role of the European Public Prosecutor's Office proved inadequate. In June 2023, only 3 months after the crime and in between the two national elections, the European prosecutors, in Athens and in Luxembourg, had a historic opportunity to uphold EU law and the principle of supremacy, and not to circumvent them. They did not. Instead, they chose to endorse the Greek regime of immunity, which guarantees impunity for politicians. Instead, they hid behind legalistic arguments. They invoked fear of an alleged statute of limitations that did not legally exist, and sent the minister's file, Spirtsis Karamanlis, to the Greek parliament. Today, Laura Kövesi claims that the Greek constitution violates EU law. Yet the signature of her office sits prominently on the decision that blessed and ratified this violation. Tempi is not the exception. It is the tip of an iceberg called the scandal management mechanism. Observe the recurring pattern throughout the years. Whether discussing the millions of euros lost through illegal EPPO subsidies or the opaque flows of the recovery fund, the sequence is always the same. Fraud is identified technocratically. Once the trail reaches a minister, the judiciary declares itself incompetent. The case file is sent to Parliament, where it becomes a field of partisan confrontation. Final outcome? Abuse of power, meaning the decision of the governing majority to block any criminal investigation of politicians, ensuring their scandalous impunity and giving them the green light to continue their criminal activity unhindered. This is not simply about protecting friends. It is an institutionalized laundering machine for criminal liability against the state and the European Union. The state pays the fines to Europe for the misuse of EU funds, yet the politicians who signed off on the actions remain untouched, protected by the infamous Article 86, crafted by themselves for themselves. As the Minister of Health and Vice President of the ruling party, Adonis Georgiadis stated without shame, "We, as the majority, will decide if we are guilty. We acquitted ourselves." This is why the discussion about Tempi and Contract 717 cannot be limited to technical details. It is a discussion about the quality of our democracy. As long as Greece maintains Article 86 as a shield, and as long as Europe tolerates and blesses this violation of legality, there will be no justice. The solution is to recognize that Article 86 of the Constitution is incompatible with the regulation governing the European Public Prosecutor's Office, with the principles of the rule of law protected by EU law, and with the European Convention on Human Rights, which guarantees fair trial and equality before the law. Ministers must be tried like every citizen, by regular judges, without permissions and without privileges. Only then will never again have real meaning. And for this reason, until the end is a historic responsibility of our society.